Zimbabwe's High Court Judge Justice Happiest Joe on Tuesday set aside Magistrate Ngoni Nduna's ruling, which had barred attorney Beatrice Mtetwa from representing veteran journalist Hopewell Chinono. This after the state had argued that Mtetwa was undermining the case by posting material related to the case on a Facebook page. Chinono had approached the court arguing that his constitutional right to a fair trial was being violated by the decision of the magistrate to bar his legal practitioner of choice from representing him. One of Chinono's lawyers, Doug Coltart, is quoted as saying that the defense team was elated that Mtetwa had been reinstated as the lead attorney. Chinono was charged with inciting Zimbabweans to revolt against President Emerson Mnangagwa's administration and spent 45 days in prison before he was released on stringent bail conditions. He was rearrested recently on charges of obstruction or defeating the course of justice. Chinono was exposed a $60 million scandal in the health ministry in the procurement of COVID-19 that resulted in President Mnangagwa's dismissing the health minister, Obadiah Moyo. He says that he's being persecuted by the Harare administration for exposing corruption in Zimbabwe. A little earlier, I spoke to Beatrice Mtetwa on the court decision, and I began by asking her thoughts about the ruling.
Good that the High Court has pronounced on this and that it has made it very clear that magistrates don't have those powers. I do not believe that the magistrate who did this did not know that he has no power. It was part of the strategy, basically to weaken Hopewell's defense. It's something that had clearly been planned beforehand, and whatever argument we might have had, and we had lots of evidence to show that I had nothing to do with the Facebook page they were complaining about, because I'm not on any sort of social media. The decision was simply to remove me. The fact that after my removal, they also instructed the prison authorities to bar me from entering any prison premises, again showed that clearly this was a planned thing in advance, because the barring order removed me from being lead counsel in Hopewell's case. It didn't stop me providing him with legal services. In fact, I could have been counsel as long as I was not in the lead, and in terms of that order, I would have been allowed. But the idea was simply to just weaken Hopewell in his defense.
I mean, it almost suggests that there's political machinations at play and political interference in a judicial process.
There can be no question that this decision was not made by someone within the judiciary, because, I mean, the magistrate now has egg on his face. It was just simply so unnecessary to do this. So clearly, this was something that was being done at someone else's instance, whether they're a politician or higher up in the judiciary, we don't know. But it certainly was orchestrated, it was pre-planned, and it was meant to interfere with the flow of the trial and Hopewell's defense.
What does this mean then generally for the judicial process? I suppose it's a relief that one court has overturned the decision of a lower court, but it is a concern that you're busy trying to defend your clients, and that sometimes the odds are stacked against you and it has nothing to do with the law.
Yeah, that's really part of the process. The idea is to distract me, because being removed from a case means that I'm unable to practice my profession. And if I'm removed, it follows that I have to undo that. And instead of concentrating on defending my clients, I have to concentrate on defending myself. And of course, everybody gets weakened there. And the idea is also to say to other lawyers, if you take on these type of cases, we can remove you from the cases in public, because, I mean, surprisingly, a whole lot of people believed that I had done something wrong, including lawyers. I mean, it was quite interesting for me that lawyers who are legally trained were part of some of those who were saying, oh, this happened because we all know Beatrice is a drama queen. She must have done something that brought this on. So the idea is to weaken Hopewell's defense, discredit me in the public domain, because people believe that a magistrate would never do that without just cause. And it's only now that the High Court has said a magistrate has no such power, that people now can see that if a higher court says that, then certainly the magistrate was on a frolic of his own, or he was deliberately disregarding the law.
I know that you're an officer of the court, and therefore sometimes some of these things are difficult to comment on, but does it mean that there are judges, justices perhaps, who are not doing their job honestly and holding the law before them first and foremost, and are either coerced or are working with political authorities to perhaps even hand down judgments that are clearly wrong?
Well, we have a creature that they have introduced into our system called the anti-corruption courts. Those courts are manned by a coterie of prosecutors and magistrates who are selected. We don't know what the criteria is. The prosecutors in the anti-corruption court are unconstitutionally housed in the president's office. They take instructions from the president's office. And you find cases that don't even fall under anti-corruption being placed in the anti-corruption court. And the reason they do that is because the anti-corruption courts, you can predict what the decision is. You go to the anti-corruption court knowing that if I make this application, I am going to lose it, because you never win anything. It doesn't matter what it is, you simply will not get any relief from those magistrates. You ask yourself, why is Hopewell's case about incitement to, alleged incitement to commit violence in the anti-corruption court? Why is his second case in the anti-corruption court when actually it has nothing to do with corruption? It is in the anti-corruption court because you are guaranteed that he'll never get bail there. Whatever relief he asks for, he'll not get it there. And he'll only get relief on appeal before the High Court. So clearly there can be no question that if you are in anti-corruption court, you will only get the kind of relief that the system allows. And the magistrates know it. They sit there, they pretend to be judicial officers, but everybody knows that they don't have any impartiality, they don't have any independence. They are hostages as much as the accused persons are. They sit up there behaving as if they are chiefs, but the bottom line is that they are also hostages. They are in the dock like the accused person because they cannot depart from the script that would have been put in front of them.
This time, a year ago almost, many of you as lawyers took to the streets to demonstrate at what was being described as the breakdown of law and order. Thousands of people had been arrested following demonstrations. A lot has happened since then. Do you think that law and order is still being violated, particularly by the authorities?
Well, the authorities will do as they please because there's absolute and total impunity. There are no consequences for them. If a magistrate, if a policeman arrest you without due process, even if there's no case against you and you go before a magistrate, you will be put on remand and denied bail on the basis that the magistrate has said so. even if you lead evidence that is almost always uncontroverted, that there's no evidence that you have committed an offense, if it is one of those political cases where the system wants you inside, you will be inside. So there can be no question that arrests are not based on people having committed crimes. Any perceived political opponent, whether real or imagined, will be arrested, and they will be put in custody, and they will be released more often than not by the High Court, because the magistrates are following that script. And they do this deliberately because they are aware that at the end of the day, if you go to trial, you're likely to be convicted. And if you are not likely to be convicted, you therefore won't spend time in custody. So they make you serve a sentence under the remand procedure before you are tried, before you are convicted. And so by the time you go to trial, even if you are acquitted, you have already spent 2 months inside anyway, and that's the intention. And the more they do it to people, the fewer and fewer people will speak out and exercise their rights and demonstrate or do whatever the Constitution says they're entitled to do, because the prisons are not very nice places to be in, particularly during this COVID period.
All right, being behind bars is not something alien to you. You've experienced this at the hands of these authorities. And I think maybe you may have even answered this question already, but are you finding that certain lawyers are getting attacked and persecuted in one way or another because of the people that they're defending? I see that one of your colleagues, Doug Coltart, himself was before the courts in August, and part of the evidence was a book that he was reading.
Yes, unfortunately for lawyers who do certain kinds of cases, each time you take the case, you know that you could very well end up sharing a cell with your client. As I speak, there are at least between 7 and 8 lawyers who are currently on remand. Virtually all of them are on remand for cases that arise directly from their representation of clients. And those clients, more often than not, are involved in activism of sorts. They're either political activists, they're civil society activists, or just citizens trying to assert their rights, like to freedom of expression, the freedom to participate in lawful demonstrations. All of the lawyers who are in custody or who are on remand are in remand because they have represented the type of person that the system does not want. So clearly there can be no question that lawyering for those lawyers who take human rights cases is as dangerous for the lawyers as it is for the clients that they represent. It is now part and parcel of being a lawyer to expect to be arrested for doing your work.
Ms. Mtetwa, is there nowhere that you can go to, an international body, to say, look, this is the situation in our country, the Constitution is being violated, and at times by those that are supposed to be enforcing it? Is there nowhere that there's recourse? Otherwise, the most vulnerable citizen whose case is not high profile, who's not known, will literally just disappear in the system and be persecuted, and that's it.
What can we do about it? Is there somewhere to go? Sadly, no, because our situation is known the world over. Everybody knows that Zimbabwe is struggling with rule of law issues, and each time that other countries try to speak out and speak up and say these atrocities must end, our government always raises sovereignty issues. We are a sovereign state. We are free to do what what we do without interference from other countries. And sadly, because this rhetoric goes back to colonial times, it gets a lot of those who might be interested not to really push things as vigorously as they ought to be pushed. And for me, until Zimbabweans themselves say we want a functioning justice delivery system, we want institutions that function as we said they should function in terms of the Constitution. I don't think somebody can come out, riding into Zimbabwe to rescue us. We have to rescue ourselves, which is why everybody should be rallying around the few people who are saying these are rights that we have, these are rights that we're entitled to enjoy, and we're entitled to treat as and when we please, we're entitled to demonstrate if we do so peacefully, we are entitled to criticize without being locked up, and we are entitled to say no to corruption without fearing being arrested. Until Zimbabweans come together and say, this is our country, this is how we want to be governed, this is how our justice system should work, I doubt very much that there's anyone who's going to come from out there to rescue us.